Two more officers in the hallway. All right, everybody, we got. All right.
Thank you, everyone. Please be seated. Okay, good afternoon, everybody. My name is Commissioner Hughes. This is the 2 p.m. initial appearance calendar for, is this me or you? Sorry. Wanted to make sure you guys heard me twice. My name is Commissioner Hughes. This is the 2 p.m. initial appearance calendar for Tuesday, April 22nd. Do I have a court interpreter on the line?
Soy la comisionada Hughes. Yes, ma'am. Would you like
Go ahead,
for
my
me to
apologies.
render that? Okay. Buenas tardes, soy la comisionada Hughes. Esta es la lista de casos para vistas incoativas de las 2 de la tarde para hoy, 22 de abril.
And thank you for getting started on the translations, Mr. Interpreter. Did you want to make your formal appearance for the recording?
Martín Hernandez, court interpreter.
Good afternoon, Mr. Hernandez. Okay,
Good
the court's orders for the taking of DNA samples and fingerprints issued on the first calendar of April will apply to the hearings on this calendar.
La orden emitida en la primera lista de casos de este mes de abril para la toma de huellas digitales y muestras de ADN aplicará a esta lista de casos.
As we get started in here this afternoon, I will call each of you into the courtroom one at a time.
Al empezar esta tarde, les estaré llamando a cada uno por uno para que pasen a la sala.
I will ask one of you to stand behind this gray podium here in front of me in the courtroom. I'll ask the next two people that I intend to call into the courtroom to line up in the two chairs right inside this door facing all of you.
A la primera persona que llame, le pediré que pase a la sala y se ponga detrás del podio que está en medio de la sala. Las siguientes dos personas que llamaré, pediré que esas personas tomen asiento en las dos sillas que están justo afuera de la sala.
Once you work your way into the courtroom and you're behind the podium, I will start by asking you to state your full name and date of birth before I explain to you why you're here this afternoon.
Al entrar en la sala, una vez que estén parados detrás del podio, pediré que me digan su nombre completo y fecha de nacimiento antes de explicarles por qué están aquí esta tarde.
After we talk about why you're here, I will tell you whether you qualify for a court-appointed lawyer to defend you. Those lawyers are sometimes called public defenders.
Después de explicarles por qué están aquí el día de hoy, les diré si califican para un abogado de oficio. En ocasiones es un abogado de la Defensoría Pública.
Whether or not you qualify for a public defender, you all have the right to the assistance of counsel in a criminal case.
Así califiquen para un abogado de oficio o no, todo mundo tiene derecho a un abogado para que les represente en una causa penal.
If you do not qualify for a court-appointed lawyer, or if you elect not to use the appointed public defender, you always have the right to hire private counsel to defend you.
Así califiquen para abogado de oficio o no. Si ustedes deciden no usar el abogado de libre oficio, ustedes pueden contratar su propio abogado.
After we talk about lawyers, I will give you the next hearing dates, the court hearing dates and times you'll have to attend after this court hearing. And the last thing we'll talk about is whether you are eligible for release from custody and on what terms if you are.
Después de haber hablado de esto, ustedes recibirán información acerca de la fecha, hora y lugar de su siguiente comparecencia. Después de eso, les informaré si califican para libertad provisional y les diré bajo qué condiciones.
In addition to that right to the assistance of counsel, you all also have the right to remain silent.
Aparte de el derecho que tienen de un abogado, todo mundo tiene derecho de no hablar.
These are recorded criminal proceedings. Anything that you do choose to say in the courtroom can be used against you at any point down the line.
Este es un proceso penal que se está grabando. Cualquier cosa que ustedes digan aquí puede usarse en su contra posteriormente.
Unless you have made arrangements with a private lawyer, there will not be a lawyer in the courtroom this afternoon for your defense.
A menos que ustedes hayan hecho un arreglo previo con un abogado privado, no habrá un abogado esta tarde para defenderlos.
And so because you won't have a lawyer and anything you say could be used against you, I will strongly caution all of you not to make any statements regarding the facts about why you're here.
Debido a que no habrá un abogado el día de hoy, y debido a que las cosas que digan aquí pueden usarse en su contra posteriormente, yo les voy a animar a que no digan nada acerca de los hechos que se alegan en su caso.
Last thing I'll tell you all before we get started is that all of the information that you get while you're in the courtroom will be contained in a written document called a release order, and you will get a copy of that when you step back into the room that you're in right now. So please keep that with you wherever you go from here.
Finalmente, toda la información que yo les diga aquí durante esta comparecencia vendrá escrita en un documento que se les entregará al final, que se llama Orden con Medidas Cautelares. Se les dará una copia. Les animo a que la cuiden y no la pierdan.
Okay, let's go ahead and get started. Can I please have Josue Morales Hernandez all the way into the courtroom behind the gray podium?
Vamos a empezar con Josué Raúl Morales. Pase por favor a la sala y póngase de pie detrás del podio.
Okay, good afternoon, sir. I'm going to ask you to state your name and date of birth for me. When you speak, will you please pull your mask down, tell me your name and date of birth, and then you can put it back up when you're done.
Señor, le voy a pedir que me diga su nombre completo y fecha de nacimiento. Cuando lo haga, por favor, retírese la mascarilla y después se la pone de nuevo.
Name and date of birth.
Nombre completo, fecha de nacimiento.
Mi nombre es Josué Raúl Hernández Morales, 22 de agosto de 91.
Josué Raúl Morales Hernández, August 22nd, 1991.
Thank you very much, sir. You are here on allegations of new charges.
Muchas gracias, señor. Usted comparece el día de hoy por acusaciones nuevas.
Those allegations are one count of dangerous drug possession, a class 4 felony.
Esas acusaciones son un punto acusativo de posesión o uso de droga nociva, un delito de categoría 4.
One count of drug paraphernalia possession, a class 6 felony.
Un punto acusatorio de uso o posesión de adminículos para el consumo de drogas, un delito de categoría 6.
And one count of engaging in prohibited conduct in a transit facility, that is a class 1 misdemeanor.
Y un punto acusatorio de conducta indebida en una instalación de transporte público. Esa es una falta de categoría 1.
I have found probable cause to support the prohibited transit conduct and drug paraphernalia allegations.
Dicto que hay fundamento fáctico para la acusación de conducta indebida en instalación de transporte público y para la acusación de posesión de adminículos para el uso de drogas.
I have not found probable cause to support the dangerous drug allegation.
Pero dicto que no hay motivos de procesamiento suficientes por la acusación de posesión o uso de droga nociva.
I have determined you are entitled to a court-appointed lawyer, and I've appointed the Public Defender's Office to represent you.
Dicto que usted califica para un abogado de libre oficio y he nombrado a un abogado de la Defensoría Pública para que le represente.
Your next court hearings on these allegations will be a status conference May 7th and then a preliminary hearing May 9th, both of them at 8:30 in the morning in the Superior Court downtown.
Sus siguientes comparecencias serán una consulta de actualización el día 7 de mayo y una audiencia preliminar el día 9 de mayo, ambas a las 8:30 de la mañana en el Tribunal Superior en el centro de la ciudad.
I am releasing you on your own recognizance on these allegations, so you will be released from custody. That means it will be your responsibility to get yourself to both of those next court hearings.
Lo dejaré en libertad bajo caución juratoria, es decir, usted estará libre y tendrá la obligación de hacerse llegar de manera oportuna a la siguiente comparecencia.
Once you are out of custody, you cannot return to the scene where you were arrested, and you cannot possess any drugs without a valid prescription.
Una vez que usted sea puesto en libertad, tendrá prohibido volver al lugar de los supuestos hechos y tendrá prohibido tener drogas sin una receta médica válida.
Do you understand those conditions?
¿Entiende esas condiciones?
Sí, sí.
Yes, yes.
Okay, thank you very much. You can work your way back to your left and get your paperwork.
Muy bien, muchas gracias. Recoja su papel ahí a la izquierda.
Mr. Interpreter, would you please make an inquiry of the gallery for me to make sure we don't miss anybody before I excuse you?
Yes, ma'am. Buenas tardes a todos. Soy el intérprete de la comisionada. ¿Hay alguien más en la sala que necesita intérprete de español? Si es así, levante la mano ahora, por favor.
No hands, Your Honor.
No hands have been raised. Thank you very much for your assistance. Mr. Interpreter, you are free to disconnect.
Thank you, ma'am.
Okay, can I please have Hayapatia Cyril to the podium in the courtroom? Antonio Garcia, if I could ask you to work your way to that first chair inside the door. Mariah Chavez, if you would please take your seat in the second chair. Can I have your name and date of birth?
Hayapatia Cyril, 42892.
Thank you, Ms. Cyrillus. You are here on two different matters. The first matter that you're here on is a bench warrant issued by the Superior Court when you failed to appear at a status conference in an existing felony drug case. You have a lawyer already assigned to you in that existing case. That lawyer will continue to defend you. Your next court hearings in that existing case will be a status conference April 28th and then a preliminary hearing May 1st, both of them at 8:30 in the Superior Court downtown. On that warrant, you have a $250 secured appearance bond. The second matter that you're here on is allegations of new charges. Those allegations are one count of narcotic drug possession, a Class 4 felony, and one count of drug paraphernalia possession, a Class 6 felony. I did find probable cause to support those new allegations, and I've appointed the Public Defender's Office to represent you. Your next court hearings on these new allegations will in part be the same as your hearings on that existing case. So you will have a status conference April 28th and a preliminary hearing May 1st. Those are the two that are the same in both cases. The difference is on these new allegations, because they are felony offenses alleged to have been committed while you were on release in that existing felony drug case, on those new drug charges, you are not eligible for release on bond, at least until you go through an evidentiary hearing. So the hearing that's different is on the new charges, you'll have one additional hearing. It will be an evidentiary hearing April 29th. It'll be at 1:30 in the afternoon. You will not be eligible for release on bond at least until after that hearing. So I encourage you to wait until after that hearing on the 29th before attempting to post the bond on that existing case's warrant. Do you understand that information?
Yes.
Okay, thank you very much. You can step back and get your paperwork. Antonio Garcia, if you would please work your way into the courtroom. Kentrell Baldwin, if I could ask you to please work your way to the second chair. Can I have your name and date of birth, please?
Antonio Garcia, 21095.
Thank you, Mr. Garcia. You are here on three different matters. The first matter you're here on is an allegation of a new charge. That allegation is one count of aggravated assault, a Class 3 felony. I did find probable cause to support that allegation, and I've appointed the Public Defender's Office to represent you. Your next court hearings on that new aggravated assault allegation will be a status conference April 28th and then a preliminary hearing May 1st. Both of those hearings will be at 8:30 in the morning in the Superior Court downtown. On that new allegation, I have imposed a $50,000 secured appearance bond. The other two matters you're here on are both probation violation warrants. In both of those cases, petitions to revoke your probation allege that you have violated terms 3, 5, and 15. I have also appointed lawyers to defend you in each of those two probation cases. Your next court hearing in each of the probation matters will be a revocation arraignment April 29th at 8:30 in the Superior Court downtown. On the two probation matters, you are not eligible for release on bond. So you will be held in custody without bail at least until you see the probation judge on April 29th. Because of that, I encourage you to wait until after that hearing before attempting to post the bond on the new charge. Do you understand that information?
Yes.
Okay, thank you, Mr. Garcia. You can work your way back to your left.
All right.
Mariah Chavez to the podium in the courtroom, please. Tyrone Jones, if you would please work your way to the second chair. Can I have your name and date of birth, please?
Maria Chavez, 10/22/92.
Thank you very much. I apologize. I thought it was Maria Chavez. Okay, Ms. Chavez, you are here on allegations of new charges. The allegations against you are 1 count of aggravated assault, a Class 3 felony, 1 count of aggravated assault while violating an order of protection, 1 count of disorderly conduct involving weapons. Those 2 allegations are Class 6 felonies. 5 counts of interfering with judicial proceedings by disobeying a court order, and 2 counts of disorderly conduct. Those last 7 counts are all Class 1 misdemeanors. I have found probable cause to support those allegations, and I've appointed the Public Defender's Office to represent you. Your next court hearings will be a status conference April 28th, and then a preliminary hearing May 1st. They will both be at 8:30 in the Superior Court downtown. On these allegations, I have imposed a $25,000 secured appearance bond. Secured appearance means that you can use a bonding company to post that bond if you choose to. If you do post that bond and you are released from custody, you cannot return to the scene where any of the underlying events took place. You cannot have contact with any alleged victims or witnesses. You cannot possess any weapons. You cannot consume any alcohol or drugs without a valid prescription. And whether or not you are released from custody, you are ordered to strictly comply with the terms of any orders of protection that have been or might later be served upon you. Do you understand those conditions?
I do accept, but can you revise the bondage of the 25 and how to proceed with that in person?
I'm not sure. Are you asking me how to get that posted?
No, can you repeat that phrasing of the bonding at the very end? Can you?
So you have a $25,000 secured appearance bond. Secured appearance means that you can use a bonding company. It doesn't have to be posted in all cash.
Oh.
If you are interested in using a bonding company to get that posted, back in the facility, there's a list of bonding companies and their phone numbers posted in just various different places. There probably are some by the phone banks if you want to go look for one there. You can call 1, 2, or all of the bonding companies on that list and see what their requirements might be and see if you can find a bonding company that can work with whatever your circumstances are.
Okay.
Is that what you were asking?
Yeah,
Okay.
and then I do have 2 court appearances.
Currently you have 2 court dates. So if you get that bond posted and you're released from custody, you will have to get yourself back downtown to the Superior Court on April 28th for a hearing at 8:30, and then again May 1st for another hearing at 8:30.
Okay, and then to rephrase, my counts are what term? Was it a misdemeanor?
So you have 7 misdemeanor allegations against you and 3 felony allegations.
Okay.
All that information will be in your paperwork. So
Okay.
keep that with you and you can review it.
Oh, yeah.
When you walk out, you can also review it with your lawyer when you go to your first court hearing.
Thank you.
Okay, any other questions, Ms. Chavez?
No.
All right, thank you very much. You can work your way back to your left. Kentrell Baldwin to the podium in the courtroom, please. Gabriel Quintero, if you would please work your way to the second chair. Can I have your name and date of birth, please?
Control Baldwin, March 2601.
Thank you, Mr. Baldwin. You are here on allegations of new charges and an allegation that the new charges violate term 1 of your probation. The new charges against you are 1 count of narcotic drug possession for sale, a Class 2 felony, 1 count of dangerous drug possession, 1 count of narcotic drug possession, those 2 are Class 4 felonies, and 1 count of drug paraphernalia possession, which is a Class 6 felony. I did find probable cause to support the paraphernalia allegation and the dangerous drug allegation. I did not find probable cause to support either of the narcotic drug allegations. So no probable cause to support narcotic drug possession for sale or narcotic drug possession. My finding of no probable cause does not mean that those narcotic drug allegations are legally dismissed. Bless you.
Thanks.
Bless you.
Thank you.
It is possible that the county attorney's office will file formal charges on those narcotic drug allegations, but I am not considering them or imposing any release conditions on them. You are entitled to a court-appointed lawyer. I have appointed the Public Defender's Office to represent you. The Public Defender will represent you against any charges that end up getting formally filed as a result of this arrest. Your next court hearings on these new allegations will be a status conference April 28th and then a preliminary hearing May 1st, both of them at 8:30 in the Superior Court downtown. On the new drug charges that I did find probable cause to support, you have a $10,000 secured appearance bond. The second matter that you're here on that I alluded to earlier is an allegation that the new charges supported by probable cause violate term 1 of your probation. I've also appointed a lawyer to represent you in that probation case. Your next hearing in the probation matter will be a revocation arraignment April 29th at 8:30. On that matter, you have a $250 secured appearance bond. So your total bond for both matters is $10,250. It is all secured appearance. You can use a bonding company for all of it. If you post that and you are released, you cannot possess any weapons or any drugs without a valid prescription. Do you understand those conditions?
Yes.
Okay, thank you, Mr. Baldwin. You can work your way back to your left.
On the left.
Tyrone Jones to the podium in the courtroom, please. Andrew Mosquera Duran, if you would please work your way to the second chair. Good afternoon, sir. Can I ask you to take your hat off and then give me your name and date of birth, please?
Tyrone 042387.
Is your last name Jones?
Correct.
Okay, thank you, Mr. Jones. You are here on allegations of new charges. If you'll leave it off just while you're at the podium, you can throw it back on when you step back to your left. Okay, the allegations against you are 1 count of aggravated driving under the influence, 1 count of narcotic drug possession. Those are both class 4 felonies. 1 count of drug paraphernalia possession, a class 6 felony. Let me get through this and I'll let you ask questions or make your statement at the end before you go back to your left. Okay, drug paraphernalia possession, class 6 felony. 1 count of driving on a suspended driver's license, 1 count of driving while being impaired to the slightest degree, 1 count of driving under the influence with a blood alcohol content of 0.08 or more, and 1 count of reckless driving. Those last 4 allegations are all class 1 misdemeanors. I did find probable cause to support those allegations, and I appointed the public defender's office to represent you. Your next court hearings will be a status conference April 28th and then a preliminary hearing May 1st. They'll both be at 8:30 in the Superior Court downtown. And on these allegations, you have a $10,000 secured appearance bond. If you post that and you are released, you cannot possess or consume any alcohol or drugs without a valid prescription, and you cannot operate a motor vehicle while this case remains pending. Okay, what was your question or statement?
You're saying narcotics, or what is that?
Yeah, so the allegation in the document provided to me by law enforcement called a Form 4 is that during the arrest, law enforcement identified and tested positive cocaine, which is legally defined as a narcotic drug.
Wow.
Any other questions?
Yeah, so a bond of $10,000?
That's right. Yeah, it's $10,000 secured appearance.
Okay, so why does it say $350?
I don't know what that is. Does he have a hold from another agency? Do you know?
Tempe, Your Honor.
So it looks like you might have a Tempe hold, and maybe the bond on the Tempe warrant is $350. I don't know. I don't have any information about what that is. But whatever that is not the new allegations that I'm seeing you on.
Okay.
Any other questions?
Yes, so when can I be released?
Well, if you post the bond on this case, you will be eligible for release. I don't know what the situation going on with the Tempe thing is. I don't know if that's something you've already been seen on and you could post that and then get out, or if they have a hold and they won't let you get released. So maybe talk to MCSO. Before posting this bond, talk to MCSO and say, if I post this, will I get out? And they can tell you globally what other holds you might have. But on this particular case that I'm seeing you on, as soon as that $10,000 bond is posted, you would be eligible for release on this case. Okay, anything else? Okay, thank you, Mr. Jones. You can work your way back to your left. Gabriel Quintero to the podium in the courtroom, please. Sean Gelbrick, if you please work your way to the second chair.
Hello.
Hi, can I have your name and date of birth, please?
Yes, Gabriel Quintero, April 8th of 2003.
Thank you very much, Mr. Quintero. You are here on allegations of new charges. The allegations against you are 1 count of stalking, a class 5 felony, 1 count of harassment by communication, and 1 count of knowingly using an electronic device to disturb an individual's peace unlawfully. Those last 2 are class 1 misdemeanors. I have found probable cause to support those allegations, and I have appointed the public defender's office to represent you. Your next court hearings will be a status conference April 28th and then a preliminary hearing May 1st. They'll both be at 8:30 in the Superior Court downtown. On these allegations, you have a $2,500 secured appearance bond. If you post that prior to your physical release from custody, you will be affixed with an ankle monitor for electronic monitoring. If you post that bond and you are released on that ankle monitor, you cannot return to the scene where any of the underlying events took place. You cannot have contact with any alleged victims. You cannot possess any weapons or consume any alcohol or drugs without a valid prescription. And whether or not you are released from custody, you are ordered to strictly comply with the terms of any orders of protection, if any have been or are later served upon you. Do you understand those conditions?
I have a few questions.
Okay.
About the stalking one, I feel like that's a little too far. I don't think that's necessary.
Talk to your lawyer. Talk to your lawyer about the underlying allegations and the facts. So at this hearing, I'm not determining that you in fact committed these allegations. I'm not finding you guilty. I am only determining that the information provided to me by law enforcement, if proven true and if they have what they say they have, it would meet the legal elements of those crimes. It's not to say that you did in fact commit them. It is certainly not to say that you don't have any defenses to these allegations. So it's just a minimum requirement that the information provided by law enforcement could support a finding that these crimes were committed. So talk to your lawyer, give your lawyer your side of the story and your facts, and you and your lawyer will determine what defenses you have or will communicate with the prosecutors to make charging decisions.
Okay, and then you said the court dates were 8 a.m. or p.m.?
a.m., 8:30 a.m. for both of them.
Okay, and then as of today, am I free to go, or?
Well, you have a bond, so you have to post that bond in order to be eligible for release. If you post that, you'll get an ankle monitor installed, and then you are release eligible.
But if I don't do that, what will happen? Like, how long?
If you don't post that bond, you'll stay in custody at least until your first hearing on the 28th. What will happen after that will be up to the judge you see on the 28th.
Okay. Well, I just don't really have like the money for that. How could I go about that? Like,
so there's three ways to get a bond posted. One is somebody could go to the 4th Avenue Bonds and Fines office and post it for you. They're open 24/7. Two is you can use money on your jail books if you have any to self-bond out. The third option, because your bond is secured appearance, is to go through a bonding company. Those are the three ways that you can get a bond posted.
Could I do the bonding company one today?
Yeah, you can start calling bonding companies as soon as you get back into the facility.
Okay.
All right, anything else?
That should be good.
Okay, thank you, Mr. Quintero. You can step back and get your paperwork. Andrew Mosquera Duran, if you would please work your way into the courtroom. Michelle Stars, if I could ask you to please work your way to the second chair.
Do I leave this right here? Or
You keep that in your hand right there is fine.
Thank you.
Can I have your name and date of birth?
Andrew Mosquera, May 1st, 2001.
Thank you very much. Is your actual legal last name hyphenated Mosquera Duran?
I don't know why it changed, like, after 2020, it just went to Duran. That's my mom's last name, so it's something to do.
What's on your driver's license or state-issued ID?
It says Andrew Mosquera.
Okay.
But it has, like, the dash Duran, doesn't it? Like, on the...
My record does. That's why I'm asking what your actual legal name is.
I don't know. It's just...
Is your actual legal name just Andrew Mosquera?
Yeah, it's just Andrew Mosquera, yeah.
Okay. All right. And your date of birth, I'm sorry, is 5/1/2001?
Yeah.
Okay. All right. Thank you, Mr. Mosquera. You are here on two different matters. The first matter that you're here on is allegations of new charges. Those allegations are one count of burglary, a Class 4 felony, and one count of shoplifting, a Class 1 misdemeanor.
Okay.
I did find probable cause to support those two allegations, and I've appointed the Public Defender's Office to represent you. Your next court hearings on those allegations will be a status conference April 28th and then a preliminary hearing May 1st. They will both be at 8:30 in the Superior Court downtown. The second matter that you're here on is a warrant issued by the West McDowell Justice Court. The underlying allegations in that warrant are 2 counts of misdemeanor driving under the influence. Both offense dates are alleged to be 10/31/2022. I don't know at what stage in the proceeding this warrant is being issued. I don't know if this is the first instance you're finding out about these misdemeanor DUI charges, or if you already know. You don't have to answer that.
Yeah, I'm just be
I don't
quiet.
want you to make any admissions, but I'm just sort of trying to explain to you why I'm about to do what I'm about to do. So I'm determining that you are entitled to a court-appointed lawyer to defend you against those misdemeanor DUI allegations. If this is a mid-stage case warrant and you already have a lawyer working with you in that case, that lawyer will just continue to work with you. But if this is the first you're finding out about these, or if you have not yet been appointed a court-appointed lawyer, I'm making a determination that you're entitled to one on those misdemeanor DUI charges. The specific lawyer that will defend you will be appointed by the West McDowell judge at your next court hearing.
Okay.
Your next hearing on that misdemeanor warrant will be an arraignment hearing April 28th at 8:30. It is the same date and time as the first hearing on your new allegations. It's a different court, though. I don't have control over those court dates.
Okay.
So what I'm going to encourage you to do is use the information in your paperwork, the phone numbers to those courts. I would encourage you to reach out to the West McDowell court, see if perhaps whatever this warrant is about could be dealt with without a court hearing. If so, try and get that dealt with. If not, ask them if they are willing to reschedule that hearing, because you're scheduled to be in Superior Court on a felony allegation at the same date and time.
For the DUI?
For the misdemeanor DUI.
Oh, for the misdemeanor DUI.
Yeah,
okay.
so call the West McDowell court, tell them you have a hearing the same date and time in Superior Court.
Okay.
Hopefully they will move that hearing date or move the time so that you can make both of them. You do have a $2,500 secured appearance bond on each matter. So if you post that bond, it'll be $5,000 secured appearance total. If you post that, you'll get out of custody and you will have to choose which hearing to go to on the 28th. So if you don't do anything, presumably you'll make one hearing, you'll miss the second, and that second court will issue a warrant for your arrest. Okay. If you don't post that bond and you stay in custody, MCSO will transport you to one of the hearings, not the other. Same situation. The court you don't go to is going to issue a warrant for your arrest. So regardless of whether or not you post that bond, you're going to want to try to make some effort to get one of the hearings on the 28th changed so you have the option of attending both of them.
Okay.
I know that was a lot of information. Do you have any questions?
So I have to post bond and get released today?
Yes.
How much?
The total is $5,000. It is secured appearance, so you can use a bonding company. If you want to explore that route, I would say call some bonding companies, see what their requirements are. But I do believe that if you can work with a bonding company, they will not require you to pay the full amount up front.
Okay. Another thing, my phone got confiscated when I was in Mesa, so, like, I don't know how I'm gonna be able to, like, get my money or anything or do anything as
So I'm not sure that's something that I can help you with. I don't know. So I hear you saying your phone was confiscated in Mesa. I don't know if it was impounded by Mesa PD as evidence.
I have the address to where it's at.
But are they willing to release it to you?
I mean, after this case is done, I'm assuming.
Yeah, so that could be a long time. So
Okay.
if Mesa PD is holding onto it as evidence, they will probably not release it until this case reaches disposition, if it gets that far.
So I couldn't even be able to go there to get my, to use
Well,
my
I don't
money,
know.
to get
Maybe.
my money sent to me? or
I don't
something?
know.
Okay.
So if Mesa PD has your phone and you want it, what I would suggest is either go down to Mesa PD if you post this bond and get out, or call them and say, hey, I was arrested by Mesa PD, my phone was taken, and that they can tell you, yeah, come on down, we'll give it back to you, or you got to wait till disposition, it's being held as evidence. Mesa PD will know that.
Okay.
But if Mesa has it and not MCSO, then you won't get access to it here in this facility.
Okay. So, bond out, find a way to call them, see if I can go receive the phone. But I got a question. If I'm already being charged with all this, isn't that kind of like, couldn't I still be able to get it because I already got charged? So it's like...
Well, you're at the allegation phase.
Okay.
So there's no formal charges yet. You'll find out whether or not the county attorney's office has formally charged this when you go to court on the 28th.
Okay.
But if your phone is being held as evidence, it will not likely be released until you reach disposition. So if charges are
until the whole
filed,
thing is finished.
you would have to wait until a guilty verdict from a jury, whether taking a plea, the case is dismissed, some way the case is fully disposed of. But Mesa will tell you that for sure. I don't know that that's the circumstance. I don't know that they're holding your phone for evidence. They might just be holding it for safekeeping. I don't know.
No, they told me.
It's being held as evidence?
Yeah, they said it is being held as evidence.
So yeah, I mean, you could still call them. They might have what they need off of that, and they'll release the phone to you. They might say, we're not releasing it until disposition. But that'll be up to Mesa.
Okay, and then let's say, like, I just didn't need the phone, but I needed a favor to send my money that's on my phone to somebody else so I can buy myself out. Is that available? Can I do that?
That's up to Mesa. I mean, it's up to Mesa as to what extent they give you access to your phone.
All right. Okay. Damn, what other questions do I have? I guess that's it.
Okay.
So just bond out today. Try to talk to a bonds person. So if it's $5,000, it's only 10% of it, right?
So you'd have to ask the bonding company what their specific requirement would be. My general understanding is that most bonding companies require a minimum of 10% down.
So
There's also requirements on the back end though. So call them. I don't want to tell you what their requirements might be and be wrong.
500. Yeah. Okay.
Yeah.
Okay. All right. Thank you so much.
Okay. Thank you, Mr. Mascara. You can step back and get your paperwork.
Appreciate you.
Sean Gelbrick to the podium in the courtroom, please. Jeff McConnell, if you would please work your way to the second chair. Can I have your name and date of birth, please?
Sean David Gilbert, 41883.
Thank you, Mr. Gelbrick. You are here on allegations of new charges. The allegations against you are 1 count of drug paraphernalia possession, which is a Class 6 felony, and 1 count of driving under the influence while being impaired to the slightest degree. That is a Class 1 misdemeanor. I did find probable cause to support those allegations, and I determined that you are entitled to a court-appointed lawyer, so I've appointed the public defender to represent you. Your next court hearings will be a status conference April 28th, and then a preliminary hearing May 1st. They'll both be at 8:30 in the Superior Court downtown. On these allegations, you have a $1,500 secured appearance bond. If you post that and you are released, you cannot possess or consume any alcohol or drugs without a valid prescription, and you cannot operate a motor vehicle if you don't have a valid driver's license. Do you understand those conditions?
Yes.
Okay. Thank you, Mr. Gelbrick. You can work your way back and get your paperwork. Michelle Stars to the podium in the courtroom, please. Victoria Smith, if you would please work your way to that second chair. Can I have your name and date of birth, please?
Michelle Stars, 10/03/1996.
Thank you, Ms. Stars. You are here on a probation violation warrant. A petition to revoke your probation was filed. It alleges that you have violated terms 3 and 5 of your probation. I've appointed a lawyer to represent you in those probation proceedings. Your next court hearing will be a revocation arraignment April 29th at 8:30 in the Superior Court downtown. On that warrant, you have a $250 secured appearance bond. If you post that and you are released, you cannot possess any weapons or any drugs without a valid prescription once you're out of custody. Do you understand those conditions? Okay, thank you very much. You can step back to your left. Okay, Jeff McConnell, if you would please work your way into the courtroom. Alexander Matson, if you would please work your way to the second chair. Can I have your name and date of birth, please?
Jeffrey Stephen McConnell, 2/29/68.
Thank you, Mr. McConnell. You are here on allegations of new charges. The allegations against you are 1 count of aggravated assault, a Class 4 felony, and 1 count of assault, a Class 3 misdemeanor. I have found probable cause to support these 2 allegations, and I've appointed the public defender's office to represent you. Your next court hearings will be a status conference May 7th and then a preliminary hearing May 9th. They will both be at 8:30 in the morning in the Superior Court downtown. Mr. McConnell, I will tell you I did receive a written recommendation regarding release conditions in this matter from the Maricopa County Attorney's Office. The County Attorney's Office has asked me to impose a $100,000 cash-only bond on these circumstances. I have reviewed your criminal history. I note that you have no substantial history of failing to appear at court hearings. I did not note any prior felony convictions. So I'm telling you this to hopefully get you to understand that the county attorney's office is considering this case very serious. They apparently feel very strongly that you should be held on a pretrial bond, and apparently they believe that the appropriate and least onerous amount in that is $100,000 cash. I am not imposing a $100,000 cash bond. Based on your lack of criminal history, I am going to release you to the supervision of pretrial services. I am going to require alcohol testing on a weekly basis. I'm also going to require an electronic monitor, so an ankle monitor, but I'm not going to require that you post a bond in order to be eligible for release. So what this means is you are going to be released from custody. You will have to check in with pretrial services for weekly alcohol testing. You will have to wear an ankle monitor while you're out on release. Once you get released from custody, you will be responsible for getting yourself to your court hearings on May 7th and May 9th. You also cannot return to the scene where the underlying alleged events took place. You cannot have contact with any alleged victims or witnesses. If these orders mean that I'm ordering you not to return to your primary residence, you can have one civil standby, which means law enforcement can escort you back to that location one time between now and your first court hearing to retrieve items you might have there that you need, whether it's clothing, toiletries, items for work, school, anything like that. If you use that civil standby because you need to go back to that location, you'll do that by calling the non-emergency number to any local police agency. Follow their instructions on how to get an officer to meet with you and take you to that location. Please retrieve anything that you might need from that location in that one time when you go back, because you only get one of those between now and your first hearing on May 7th. Go ahead.
I have a couple questions. One is, the ankle monitor, does that mean I'm on house arrest type of thing?
No, I'm not imposing a restriction of house arrest, just a tracking of your movement.
Oh, okay. And the second one was, shoot, I forgot already, but okay.
Okay.
So that, the number that I'm supposed to call, I'll have all that information? They're gonna give me all that?
To establish alcohol testing?
No, well, yes.
Yes, it will be in a little packet. You'll get your release paperwork, and then you'll get a little packet that has all of pretrial's contact information. But you will get in, that ankle monitor will be installed on you prior to your release. So when they're meeting with you to put that ankle monitor on, you can always talk to them then and see if you can get the first testing set up or anything. They might just say when you get out, call and do it, but you'll get an opportunity to talk to somebody from pretrial before your release.
Okay.
All right, thank you very much, sir. Victoria Smith to the podium in the courtroom, please. Scott Hunt, if you would please work your way to the second chair. Can I have your name and date of birth, please?
Victoria Annette Smith, 10/21/67.
Thank you very much, Ms. Smith. You are here on an allegation of a new charge. That allegation is one count of discharging a firearm in the city limits. It is a Class 6 felony. I did find probable cause to support that allegation, and I've appointed the Public Defender's Office to represent you. Your next court hearings will be a status conference May 7th and then a preliminary hearing May 9th. They will both be at 8:30 in the morning in the Superior Court downtown. I am releasing you to the supervision of pretrial services, so you will be released from custody. You do not need to post a bond. Once you are out of custody, you will be responsible for contacting pretrial services. Their contact information will be in a packet you get with your release order, so please keep that so you can call them when you're out of custody. Also, once you are out of custody, you are prohibited from possessing any weapons, and you cannot possess or consume any alcohol or drugs without a valid prescription. Do you understand those conditions?
I do.
Okay, thank you very much, Ms. Smith. You can step back to your left and get your paperwork. Alexander Matson to the podium in the courtroom, please. Robert Gutierrez, if you would please work your way to the second chair. Can I have your name and date of birth, please?
Alexander Matson, 8/17/88.
Thank you, Mr. Matson. You are here on allegations of new charges. The allegations against you are one count of dangerous drug possession, a Class 4 felony, and one count of drug paraphernalia possession, a Class 6 felony. I did find probable cause to support those allegations, and I've appointed the Public Defender's Office to represent you. Your next court hearings will be a status conference May 7th and then a preliminary hearing May 9th. They will both be at 8:30 in the Superior Court downtown. I am releasing you on your own recognizance, so you will be released from custody. That means it will be your responsibility to get yourself to both of those court hearings. Once you are out of custody, you are ordered not to possess any drugs without a valid prescription. Do you understand those conditions?
Yes, Your Honor.
Okay, thank you very much. You can work your way back to your left. Scott Hunt to the podium in the courtroom, please. Santino Vasquez, if you would please work your way to the second chair. Can I have your name and date of birth, please?
Scott Hunt, September 29th, 1983.
Thank you, Mr. Hunt. You are here on a failure to comply with court terms warrant issued by the Goodyear Municipal Court. The underlying allegation in that case is a misdemeanor disorderly conduct allegation. Because this appears to be a post-adjudication misdemeanor matter, you're no longer entitled to a court-appointed lawyer going forward, or a new one. If you have one that's working with you, that lawyer might continue to work with you. But if not, and you want a lawyer moving forward, you will have to hire a lawyer to work with you in this case.
Okay.
Your next court hearing on this warrant will be an arraignment hearing May 7th. It will be at 1 o'clock in the afternoon. It will take place in the Goodyear Municipal Court. I am releasing you on your own recognizance, so you will be responsible for getting yourself to that court hearing.
Okay.
Once you are out of custody, you cannot possess any drugs without a valid prescription.
Okay.
Do you understand those conditions?
I do.
Okay, thank you, Mr. Hunt. You can step back and get your paperwork.
Thank you.
Robert Gutierrez, if you would please work your way into the courtroom. Daniel Kirichenko, if you would please work your way to the second chair. Just right there. Have a seat. Oh, he's asleep? That's fine. We'll get him. Can I have your name and date of birth?
Robert Gutierrez, June 13th, 1990.
Thank you, Mr. Gutierrez. You are here on two different matters. The first matter that you're here on is an allegation of a new charge. That allegation is one count of dangerous drug possession. It is a Class 4 felony. I have found probable cause to support that allegation. Based on your reported financial situation, you don't financially qualify for a court-appointed lawyer to defend you. So that means you will have to hire a lawyer to represent you against that allegation if you wish to be represented. Your next court hearings on that dangerous drug allegation will be a status conference May 7th and then a preliminary hearing May 9th. They will both be at 8:30 in the Superior Court downtown. The other matter that you're here on is a failure to comply with court terms warrant issued by the North Mesa Justice Court on a misdemeanor driving on a suspended license allegation. Because that appears to be a post-adjudication misdemeanor matter, you're also not entitled to a court-appointed lawyer on that misdemeanor warrant. Same situation, you do still have the right to counsel. If you wish to be represented, you can hire a lawyer to defend you in that case as well. Your next court hearing on the misdemeanor warrant will be an arraignment hearing May 8th. It will be at 1 o'clock in the afternoon in the North Mesa Justice Court. On both of these matters, I am releasing you on your own recognizance. So you will be released from custody and you will be responsible for getting yourself to all of your next court hearings. Once you are out of custody, you are ordered not to possess any drugs without a valid prescription, and you cannot operate a motor vehicle if you don't have a valid driver's license. Do you understand those conditions?
Yes, ma'am.
Okay, thank you very much.
Thank you.
You can step back. Santino Vasquez to the podium in the courtroom, please. Right here behind this gray podium, if you would. All right, can I have your name and date of birth, please?
Santino Daniel Vasquez, 12/19/1992.
Thank you, Mr. Vasquez. You are here on an allegation of a new charge. The allegation is one count of dangerous drug possession. It is a Class 4 felony. I did not find probable cause to support that allegation.
Yeah.
My finding of no probable cause does not mean it is legally dismissed. It is possible that the county attorney's office will file charges on that, but my finding of no probable cause does mean that you will be released from custody without any release restrictions. I am appointing a lawyer to represent you. In the event that the county attorney's office does file charges on this allegation, you are entitled to a lawyer, so I have appointed one for you. I'm also going to give you court dates. So you have to go to court on May 7th at 8:30.
Okay.
And then depending on what happens on the 7th, maybe again May 9th at 8:30. So here's the deal, Mr. Vasquez. If you don't go to court on May 7th and the county attorney's office filed charges, that court's going to issue a warrant for your arrest.
Okay.
When you go to court on the 7th, if no charges are filed, the court will tell you no charges have been filed, you're free to go.
Okay.
But make sure you're there, because if charges are filed and you don't go, you're going to end up back here at some point when you get picked up on that warrant that they issue.
So I'll make it to my interview, right?
I don't know what that means.
Like I'm not gonna stay here?
You're eligible for release, so you're going to go to release.
Okay.
Assuming you don't have any other holds, you will get released from custody. The release process can sometimes take several hours, so I don't know what interview you have to get to. It's almost 3 o'clock right now, so you'll go to release, but you could still be here a couple hours.
Okay.
All right, thanks, Mr. Vasquez. Daniel Kirichenko to the podium in the courtroom, please. Did he give the FOJ card? Okay. Can I have your name and date of birth, please?
Daniel James Kirichenko, 10/24/90.
Thank you very much, Mr. Is it just pronounced Kirichenko?
Kirichenko.
Kirichenko. Okay. Thank you, Mr. Kirichenko. Okay, you are here on 2 different matters. The first matter that you're here on is an allegation of a new offense. That allegation is 1 count of criminal trespassing. It is a Class 3 misdemeanor. Because that is a misdemeanor allegation, the nature of that charge does not entitle you to a court-appointed lawyer. If you wish to be represented on that criminal trespassing allegation, you do have the right to counsel. You will just have to hire a lawyer to defend you. Your next court hearing on that new misdemeanor allegation will be an arraignment hearing April 25th. It'll be at 8:30 in the morning in the Encanto Justice Court. And on that matter, you have a $50 secured appearance bond. 50. Okay, second matter that you're here on is a felony warrant issued by the state of California. Before you were put on a court docket here in Arizona, Arizona court staff confirmed with California that is a valid warrant. California has indicated that they are willing to extradite you. Because of that, your hearing is going to look a little bit different than everybody else's. I am going to give you 2 different choices that you can make on the California warrant. I'll give you an opportunity to ask any questions that you have about either choice, but at the end of that, I will ask which option of the 2 that you choose on the California warrant. Okay, so before you walked into the courtroom when you were still in the gallery, did you get a big laminated card to review? Can you say yes or no out loud, please?
Yes.
Okay, did you read through that card?
Yes.
Okay, as I indicated, you will have a choice to make between 2 different options on the California warrant. Your first option is to waive your right to an extradition hearing here in Arizona. If you do that, you are agreeing to go back to California. If you waive your right to an extradition hearing here and agree to go back to California, you are not waiving any rights or defenses you have to the underlying criminal case in California. You are only waiving an extradition hearing here in Arizona, and you're agreeing California authorities can come to Arizona and take you back to California. If you pick that option and you waive your right to an extradition hearing, you will be held in custody here in Maricopa County for up to 30 days without bond to allow California an opportunity to come get you. That 30-day time period, though, will not start ticking until the new local charge reaches disposition. So if you pick option 1 and you waive your right to an extradition hearing, you will be held in custody without bail until the misdemeanor case is resolved, then 30 days.
So I'm pretty fucked because you gave me $50 bail, right?
Well, if you pick option 1, you don't get to post bond. You'll stay in custody regardless. Let me get to option 2 and then we'll talk about that. So the short answer to your question is not necessarily. If you pick option 2 and you do not waive your right to an extradition hearing, I will set an extradition hearing on a California warrant for May 5th at 1:30 in the afternoon. If you pick option 2 and that hearing gets set, extradition proceedings in Arizona are civil, not criminal, which means I can't appoint a lawyer to represent you in the extradition proceedings, but you do still have the right to hire a lawyer if you want a hearing and you want to be represented in that hearing. If you pick option 2 and I set that extradition hearing, Governor's warrants are then sought by the governors of Arizona and California. Once both governors sign warrants, that's what requires Arizona to release you to California and what allows California to come to Arizona and take you back. That process of obtaining a governor's warrant could take up to 90 days. So if you pick option 2, that period is 90 days, but in option 2, you are bond eligible on the California warrant. So if you pick option 2, your bond on a California warrant is $25,000 secured appearance. So if you picked option 2 and you posted bond for both of these cases in the amount of $25,050, you would be eligible for release from custody. You'd be required to stay in Arizona, and you would be required to get yourself to all of your hearings in that misdemeanor case and the extradition case. But if you pick option 2, you do have the option of posting bond to be eligible for release from custody. Okay, do you have more questions, or do you need clarification on either of the 2 choices you have?
No, I'll take option 2.
You want to have an extradition hearing?
Yeah.
Okay, then I will set that hearing for May 5th at 1:30. You will have a $25,000 secured appearance bond, making your bond for both cases $25,050. You can use a bonding company to post all of that. If you do post that bond, like I said, please stay in Arizona, get yourself to all of your court hearings, and if you are released from custody, you can't possess any drugs without a valid prescription. Okay, do you understand all of that information? Any final questions?
No.
Okay, thank you very much, Mr. Karachenko. You can work your way back to your left. We'll bring your paperwork out to you here shortly. Okay, number 5 on the calendar, Zachariah Allen Kraft, date of birth 12/4/1990, is not in the courtroom because he was unable to function in general population due to combative behavior. He is here on allegations of new charges. Those allegations are 1 count of aggravated assault, a Class 3 felony, and 1 count of aggravated assault, a Class 5 felony. I did find probable cause to support both allegations, and I appointed a public defender to represent him. His next court hearings will be a status conference April 28th and a preliminary hearing May 1st. They'll both be at 8:30 in the Superior Court downtown. He has a $25,000 secured appearance bond on those allegations. Number 12 on the calendar, Anthony Ray King, date of birth 9/13/84, is not in the courtroom because he was unable to function in general population due to disruptive behavior. He is here on 2 different matters. The first is allegations of new charges. Those allegations are 1 count of criminal trespassing in a critical public service facility, a Class 5 felony, and 1 count of drug paraphernalia possession, a Class 1 misdemeanor. I did find probable cause to support those allegations. I appointed a lawyer to defend him. His next court hearings on the new charges will be a status conference April 28th and a preliminary hearing May 1st, both at 8:30 in the Superior Court downtown. He's also here on an allegation that those new violations constitute Term 1 probation violations. I've appointed a lawyer for him in the probation case. His next court hearing in that matter will be a revocation arraignment hearing April 29th at 8:30 in the Superior Court downtown. On each of these 2 cases, he has a $500 secured appearance bond, making his total bond $1,000, all secured appearance. Number 18 on the calendar, Jonelle Lamore Haynes, date of birth 10/10/95, is not in the courtroom because he was unable to function in general population due to combative behavior. He is here on allegations of new charges. Those allegations are 1 count of dangerous drug possession, 1 count of narcotic drug possession, those are both Class 4 felonies, and 1 count of drug paraphernalia possession, a Class 6 felony. I did find probable cause to support all of those allegations with the exception of the dangerous drug allegation. I did not find probable cause to support that allegation. I appointed a lawyer to defend him. His next court hearings will be a status conference May 7th and a preliminary hearing May 9th, both at 8:30 in the Superior Court downtown, and I am releasing him to the supervision of pretrial services. Last on the calendar, number 11, Justin Ivan McBurney, date of birth 11/5/2003, is not in the courtroom because he was unable to function in general population due to combative behavior. He is here on 3 different matters. The first is allegations of new charges. Those allegations are 2 counts of burglary by use of a master key. They are alleged to be Class 4 felonies, and 1 count of damaging a vehicle without the owner's consent, a Class 3 misdemeanor. I did not find probable cause to support any of these allegations. I have appointed a lawyer to defend him in the event that charges are filed. His next court hearings that he'll be required to attend will be a status conference May 7th and then a preliminary hearing May 9th, both at 8:30 in the Superior Court downtown. Because I did not find probable cause to support the new allegations, I also did not find probable cause to support the 2 alleged Term 1 probation violations. Likewise, I've appointed a lawyer for him in both probation cases. We'll give him a court hearing. It will be a revocation arraignment April 29th at 8:30. So he will be released from custody because no probable cause was found to hold him on any of these allegations. He does have a lawyer in all cases, and I will give him his court dates. If anything changes after I visit any of these individuals' cell side, the court's final orders regarding release will be reflected in the written release orders. That concludes the 2 p.m. initial appearance calendar. This court will stand in recess until 5 p.m.